welcome everybody. A proper lecture series in this Oxford theatre requires at least traces of legal history. Now, I don't count Steve's personal reminiscences from the 1970s as proper legal history. Sorry, Steve. So here's my take. The international sports organizations are not the first to have created jurisdictional bubbles, making sure that members forsake access to state judiciaries. I'm speaking of the Church or churches, and the Church of Rome is the nearest example. For centuries, the Roman Church exercised exclusive jurisdiction over its ground personnel. For centuries, intricate questions arose about the borderline between this organization's internal law, if I may pick up the term, and its jurisdiction and its relationship with external secular laws, and these difficulties troubled the legal world constantly. The immersion of the member into the organization was so comprehensive that the term mors civilis, more civil, the civil death, was coined. You lost all your legal personality as recognized by the external or secular laws. Well, this is something the sports world has yet to achieve. Olympian athletes are not medieval nuns. By the way, the military is another organization that maintains a jurisdictional bubble, as did for a while this university. Now, for English civilization, the person engaged in, immersed in a sporting activity is a role model. It's perhaps the role model par excellence. You are a good sport. You play by the rules. Something is play fair or foul. You keep the ball rolling. You are in a sportive mood, even if sometimes you see something that is not cricket. In the first two lectures, we have learned that the highly commercialized world of modern sports organizations has moved away considerably from the visual poetics of the idyllic cricket field. Today is the time, I think, we need to be shown some silver lining, and that is what I hope for today. Steve, the floor is yours.
So on Monday, I talked about how sports governing bodies aspire to autonomy, to the creation of this jurisdictional bubble that Wolfgang has just so felicitously described. How sports bodies seek to establish that their internal practices shall resist review from external sources, most of all state law and European Union law, sometimes for compelling reasons. Sports governing bodies convincingly explain that they have greater expertise in understanding their sport than politicians, greater expertise in solving disputes in sport than judges. And there is a need in sport for global rules which are not fragmented along national jurisdictional lines. So there is good sense to the appeal for sporting autonomy which governing bodies so commonly make. And in practice, it's delivered by the commitment to arbitration, which is so common across so many sporting disciplines. But as I explained, public policy asserts a role in intervening insofar as arbitral finality might collide with public policy and therefore need to be corrected. And then the quest for autonomy which governing bodies pursue shifts from contract, the consensual commitment to arbitration, to interpretation, an attempt to persuade courts before which sporting practices are addressed that the law should be interpreted in a way that is sympathetic to the claimed special circumstances of sports governing bodies. And on Wednesday I talked about the European Union as a case study in this vein, in which we explore whether the special features of sport may dictate a different interpretation of EU internal market law from that which would apply to sausage makers. And I explained that there is an autonomy granted to sports governing bodies by EU law, which is conditional on those sports governing bodies demonstrating that they have a special need for particular practices which wouldn't be found elsewhere. The transfer system, the role of governing bodies in authorising sports events as gatekeepers. How long have you got? We've already been down this road to some extent on Monday. We remember that the last World Cup held in 2018 was held in Russia, 4 years after Russia had invaded and illegally occupied Crimea, Ukrainian territory. There's the World Cup. There's Gianni Infantino, the president of FIFA, and there's President Putin. There's President Putin again, handing over a medal to President Infantino. And the next World Cup, as you're fully aware, is to be held starting on Sunday in Qatar. Let's think a bit more about the process which has delivered the World Cup to Qatar. In 2013, the FIFA president of the time, Sepp Blatter, has admitted world football cannot turn a blind eye to the deaths of hundreds of construction workers in Qatar as the country prepares to host the 2022 World Cup. Well, he was as good as his word. It's estimated that in excess of 6,000 construction workers have died in the preparation for this World Cup. We know, too, that labour standards applicable to migrant workers are pretty poor on paper and worse in practice in Qatar. We know, too, that there is a patchy respect for internationally recognised human rights standards in Qatar. The most high-profile example of that being that it is illegal to perform homosexual activities in Qatar. C'est l'humanité. Qatar, le grand braquage du sport, braquage, robbery. How the soft power of Qatar has eaten football. Okay, you might want to dismiss humanité as woke left-wing whining. You wouldn't dismiss the Frankfurter Allgemeine Zeitung in that vein, but here's what it had to say just a week ago. Qatar's World Cup ambassador calls homosexuality mental damage. And he says he has concerns about the risk that children in Qatar may see gay tourists attending the World Cup. Earlier this week, former FIFA President Blatter says picking Qatar as World Cup host was a mistake. Oh, Sepp, who knew? Many stories about the process that led to the delivery of the World Cup to Qatar abound. Les méthodes sulfureuses du Qatar. Blatter says he voted for the United States to host the 22 tournament and blames then UEFA President Michel Platini for swinging the vote in Qatar's favour at the behest of then French President Nicolas Sarkozy. Sarkozy had recommended to Platini that he and his people should vote for Qatar, Blatter said. The former FIFA president's version of events has been denied by Platini. The rats are fighting in a sack. Well, does the current FIFA president, Gianni Infantino, care? Well, here's what he said a few weeks ago in a letter which was sent to the national associations of the countries that have qualified for the Qatar World Cup. He said, "At FIFA, we try to respect all opinions and beliefs without handing out moral lessons to the rest of the world. One of the great strengths of the world is indeed its very diversity, and if inclusion means anything, it means having respect for that diversity. So, please, let's all remember that, and let football take centre stage. Bread and circuses." The World Cup in 2014 was held in Brazil. At the time the award of the World Cup was made to Brazil, it was forbidden to sell alcohol in football stadiums for fear of public disorder. That didn't sit well with FIFA. FIFA General Secretary Jerome Valque said the right to sell beer must be enshrined in a World Cup law the Brazilian Congress is considering. Alcoholic drinks are part of the FIFA World Cup, so we're going to have them. Excuse me if I sound a bit arrogant, but that's something we won't negotiate, he said. The fact that we have the right to sell beer has to be a part of the law. And so it was. You could get Budweiser in the stadiums that stage World Cup matches in Brazil. FIFA prevailed. Brazil changed its law. Well, we should be grateful that FIFA's no longer quite so arrogant because they hadn't expected Qatar to change its rules on worker rights or on human rights. FIFA seems really rather selective in the values which it wishes to prioritise. On Tuesday, 2 days ago, Gianni Infantino, the president of FIFA, addressed the meeting of the G20 heads of state and government in Indonesia. What? War, climate change, recession, refugees. But the politicians have got enough time to have a chat with a football man. He tells you something about FIFA's immense political clout, that Infantino is able to be heard in an event of that magnitude. What did he say? There he is, looking thoughtful. Soccer FIFA boss Infantino urges World Cup ceasefire in Ukraine. My plea to all of you, he said on Tuesday, is to think on a temporary ceasefire for 1 month, the duration of the World Cup, or at least the implementation of some humanitarian corridors, or anything that could lead to the resumption of dialogue as a first step to peace. We know in recent weeks that the Ukrainian forces have been successful in liberating parts of territory previously occupied by the Russians, but they haven't been successful completely so far. President Infantino has a message for those Ukrainian citizens who live in areas of the Ukraine which remain under Russian occupation. He's got bad news for them, but he's got good news. The bad news is that he is calling for a pause. He's calling for their occupation to continue for a little while longer. But there's good news too. There'll be some football for them to watch on telly. Won't go on. Here are the reasons why we need to be concerned about the power which is wielded by sports governing bodies generally and by FIFA in particular. We can worry about corruption, but we can also worry about structural problems which flow from the governance model which applies in sport generally, in football in particular. We should worry about intransparency. We should worry about absence of equality. We should worry about absence of adequate representation and accountability. Look, FIFA does some great things, by the way. Age group competitions are enormously important in developing the career of young footballers. A huge amount of money is moved to developing countries to accelerate their football competitions. Women's football has never had a higher profile than it has today. A lot of that is down to the excellent work done by FIFA. And FIFA has some genuinely excellent employees who have an admirable commitment to acting for the good of the game. But when it comes to the big cause, when it comes to hosting the World Cup, FIFA's taken some wrong turnings. And it's done it largely because of the governance model which prevails within football. This is the pyramid structure of football governance that I've shown you on Monday and also on Wednesday. Decisions are taken in football at the top of the pyramid by FIFA, the regulatory authority for the whole world. Its decisions on how the game shall be run percolate downwards through the continental federations to the national football associations, which structure their competitions according to the rules dictated by FIFA. And FIFA also acts as a commercial exploiter of the rights created by the delivery of football competitions. The reason the World Cup was in Russia and is in Qatar was that the Executive Committee of FIFA voted for that. And the members of the Executive Committee of FIFA are all voted into place by the national football associations and by no one else. It's a closed system of governance. FIFA's powers come from the votes which are delivered by the national football associations, over 200 of them. There is no direct voice, big decision-making at FIFA level for clubs. There's no voice for players. There's no voice for fans. There's no voice for civil society. So that's the way decisions get taken in a closed system of governance. To me, there have been far too many scandals and far too many missteps in sports governance over recent years for us to be satisfied with the status quo. It needs changing. It won't be changed from within. That pyramid system of governance enshrines a structural problem. The structure of governance in sport is that the voices of football insiders determine what happens. The national football associations, and only the national football associations, are the electorate from which the powerful individuals who make FIFA's decisions are drawn. The full range of affected interests, affected by FIFA's decisions, clubs through players, fans, are not represented at all. Who can put it right? The European Union. Only the European Union. It's partly a geographical claim. For most sports, Europe is the economic heartland, which means that the European Union is an influential actor. Also, headquarters of most sports governing bodies are in Switzerland, which is not in the European Union, but is within its regulatory orbit. But especially the case for the European Union is that it's a transnational bloc of 27 states. It's really difficult for a state on its own to challenge FIFA's monopoly of regulatory authority. One state, even a powerful state, will find it very difficult to disturb FIFA's power. Not least because of FIFA's ability, sometimes used to exclude countries from competitions where the governments of that country seek to intrude on the monopoly, the autonomy which FIFA claims over its activities. The European Union's in a much stronger position than an individual state because it's 27 states acting collectively, which by sheer force of numbers have a greater power, but especially are resistant to sanctioning. FIFA cannot suspend all 27 countries which play football within the European Union, or at least If it did so, it would be left with a tournament that was commercially much weaker, because football's heartland is in the European Union. So the European Union is really the only entity on the whole planet that is capable of taking FIFA on, seeking to correct the malfunctions in governance which we see at FIFA level. So really an important theme here is, if not the European Union, then who? As I explained yesterday, the European Union already plays a significant role in the regulation of sport in general and football in particular. And I tried to explain yesterday that the way in which the Court of Justice has interpreted and developed competition law in application to sport is quite fascinating and demonstrates sensitivity on the part of the Court to the virtues of competition, but also the specific characteristics of sport. Might dictate sometimes a tolerance of coordination, reflecting the interdependence of participants in a sports league that you wouldn't find elsewhere. It might also sometimes generate a suspicion of the dominant regulatory power that governing bodies assert in sport. That's, as I tried to explain yesterday, a fascinating story of legal interpretation, in which the Court of Justice tries to meld together internal market laws assumptions and the claims to sporting autonomy. But, as I finished on yesterday, what the EU does in applying competition law is typically reactive, unsystematic, ad hoc. The decisions arrive through the accidents of litigation. Bosman arrives simply because of the oddities of that individual's career. The Maker Medina case, same story. Greek motorcycling threw up a very important decision by chance. It's reactive, it's unsystematic, it's ad hoc. And the point of EU competition law is to determine what may not be done. Not to mandate legislative standards against which sport shall be measured into the future. And competition law operates according to its own expectations and norms. It doesn't extend beyond market analysis. It doesn't deal with questions of good governance, of equality, of representation. At least, if it does do so, it does so only indirectly. So the argument, the case they want to make, is that the EU needs to go beyond an exclusive focus on competition law as a means to discipline sport and supplement that with ex-ante regulation. That the EU should legislate to put in place the standards that must be met by governing bodies which wish to offer sports services on the market in the European Union. So, EU sports law should be transformed from a focus on ex-post application of competition law to instead a regime which adds together both ex-post facto application of competition law and ex-ante application of legislative tax standards which set the terms on which sport shall be conducted in Europe. Give you an example of what I'm talking about, what's at stake in this idea that the existing structure is inadequate and needs to be supplemented. In 2021, the Committee on Culture and Education of the Parliament referred to a European sports model that recognises the need for a strong commitment to integrating the principles of solidarity, sustainability, inclusiveness, open competition and sporting merit, governance, diversity, inclusion, discrimination. Get a whiff of that through competition law. I mentioned yesterday the decisions of the Court of Justice in Moto and of the General Court in the International Skating Union case. Both of these cases in which the courts held that a sports governing body has a legitimate role as a gatekeeper in its sport. That's to say, sports governing bodies may legitimately decide which events shall be authorised, which shall not, so as to create a coherent calendar for their sport. But in both cases, it was insisted that where the governing body makes decisions about which events to allow and which events to prevent, it shall do so according to objective, transparent, non-discriminatory criteria, which are open to judicial review. That's a nudge towards good governance. That's competition law being used to establish a role for sports governing bodies as gatekeepers, on condition that they do so in a way which complies with standards of good governance and fairness. That's fine as far as it goes. But it doesn't provide the sort of systematic, comprehensive programme of good governance which the Committee on Culture and Education of the Parliament wishes to see in place. If you're really going to put in place a systematic programme integrating the principles of solidarity, sustainability, inclusiveness, good governance, diversity, inclusion, you can only do that through legislation, which sets the standards which must be met by sports governing bodies. You can't get to something as comprehensive as that through the ad hoc application of competition law. Similar story, I have to say, the need for something more than competition law to make sports law viable emerges from the European Super League company case. This is the case that I mentioned yesterday, where 12 clubs put in place proposals for a new Super League to which those 12 clubs would automatically qualify and would also be protected from relegation for a defined period. All of which is contrary to the usual assumptions of merit-based qualification for sporting competitions allied to promotion and relegation. And as I mentioned yesterday, those 12 clubs contain some of the most famous and successful clubs in European football, but by no means would those 12 be the 12 best and most successful. I think, as I mentioned yesterday, about the great clubs that are missing. UEFA, as we know, took action to deter, to penalise participants in a breakaway league. And the question that was raised before a court in Madrid was whether UEFA's reaction to the Super League was compatible with EU competition law, or whether instead it was an abuse of a dominant position. In the case which is before the court, and will be decided in the first half of next year, the claim of the Super League clubs was essentially a competition law-based claim. They presented the Super League as a new competition which would compete with the existing UEFA Champions League, and it would be up to the consumer to decide which competition should prevail. Orthodox competition law thinking would say that's a pretty powerful argument. UEFA's argument is the defence of sporting integrity. UEFA's argument is that they are seeking to protect the European sports model by suppressing the risk of a breakaway competition. So UEFA will say, we need one competition to generate the champion of Europe. We don't want European football to look like boxing. UEFA will say, we need to have open leagues and merit-based qualification. We don't want closed leagues. We want European football not to look like North American sport. UEFA is presenting itself as the defender of the European sports model. Really interesting issues, really interesting tension. It is, as I suggested yesterday, right at the thematic heart of sports law, to decide when the orthodox assumptions of competition law should be adjusted because they are being applied in the particular context of sport. The problem is that the issues raised by the Super League litigation go far beyond those that can be readily resolved through EU competition law. The issues that are at stake are economic and cultural as well as legal. What's at stake is what value attaches to the European sports model? Who defines it and how? What legal character does it have? We might, for example, in thinking about the design of European sport, accept the need for a regulator, but we might doubt whether the regulator needs also to be the organiser of the competition. So perhaps UEFA's role should be separated, leading to a restructuring of the market for sport in Europe. We might wonder whether UEFA really objected to a closed league, or whether they really objected to a closed league that they didn't own. We might wonder too whether the clubs really wanted competition or instead destruction of the UEFA model and dominance for their own model. These are all big questions which are clearly at stake in the debate about whether the Super League should thrive or die. They can readily be resolved through the application of competition law, which in formal terms involves the court deciding what may not be done. In the name of competition law, it's not the job of the court to mandate the shape of the European model of sport. So again, I draw from that there is a need for something more in EU sports law than the ex-post application of competition law. There is a need for ex-ante, proactive, systematic regulation to put in place, clearly, the standards which govern access to and the operation of sports markets in the European Union. That would make the picture more predictable. It wouldn't be necessary to go litigate to find out what's allowed and what's not. Legislation would deliver a more predictable model. It would also deliver a more politically legitimate model. Legislative commitment to the shape of European sport would be delivered through the political process in a way that is far more satisfying than we can achieve through the application of competition law in individual cases. So that's the argument. The EU should set standards which apply to the regulation of sport which must be met by governing bodies wishing to operate in the European Union in the field of sport. Quickly, because this is a relatively technical EU constitutional point, there's a question of whether the EU may do any such thing. The European Union may not simply regulate as it sees fit. The European Union may do no more than its treaties permit. And it's clear that the European Union may not simply regulate as a general claim. The tobacco advertising case mentioned there on the slide is the most dramatic example in which the Court of Justice invalidated a directive on tobacco advertising on the basis that the legislature had asserted a general regulatory competence which the treaty does not confer. But the treaty does confer a competence on the European Union to harmonise laws insofar as that harmonisation contributes to the better functioning of the EU's internal market. I feel pretty confident that the EU legislature could identify disparities between national regulation of sport, which would justify the adoption of EU harmonised common standards on sport, thereby to promote the better functioning of the internal market. And the case law of the court in more recent times shows just how indulgent the court is to those kinds of claims. So, in short, I'm arguing that the EU's claim to be able to regulate sport is constitutionally validly based on its claim to be able to establish common standards in order to make the internal market work better. So the constitutional basis for legislative action affecting sport is, I think, secure. But will the European Union do more? Is there political will to adopt legislative proposals and legislative measures that would provide the ground rules for the pursuit of sports governance within the European Union? In the 2007 Commission white paper, it's very obvious that the Commission was extremely reticent about any notion that the European Union should become a legislator in the field. It admitted that any attempt at precisely defining the European sport model quickly reaches its limits. And the white paper is shot through with a nervousness about seeking to describe and to impose a particular model on sport, indeed on sports. Not all sports are the same. But the mood is clearly changing, not least, I suspect, as a result of the continuing wave of scandals that attend sport in Europe and beyond. So in 2019, in the conclusions of the Council and representatives of the Member States on combating corruption, it was stated that sports governing bodies should be able to maintain a high degree of autonomy in fulfilling their role in all fields of sport. This comes with an implicit recognition that any such autonomy must be earned through good governance and upholding the highest standards of integrity in their sport. So there's an explicit linkage there between the concession that the EU is willing to make to sporting autonomy and the conduct of sports governing bodies enjoying that autonomy. This is a quote I gave you earlier, which I returned to from the Committee on Culture and Education of the Parliament, referring to a European sports model that recognises the need for a strong commitment to integrating the principles of solidarity, sustainability, inclusiveness, open competition and sporting merit, good governance, diversity, inclusion, non-discrimination. That can only be delivered by legislative action. If the European Union is really going to make those principles real, it will need to legislate in order to achieve them. That cannot be achieved indirectly through the application of internal market law. Similar point from a resolution of the Council and representatives of the Member States on the key features of a European sports model, which are, such as freedom of association, pyramidal structure, open system of promotion and relegation, grassroots approach and solidarity, a role in national identity, community building and structures based on voluntary activity, as well as its social, educational, cultural and health functions. That could be a rather vague aspirational catalogue, or, if it's to be given real, concrete legal shape, it needs to be delivered through legislative instruments which specify that these standards shall be attained, probably how they shall be attained. There's even a so-called European Citizens' Initiative, labelled Win It on the Pitch, which encourages the Commission to prepare a legislative initiative to protect a European model of sport based on values, solidarity, sustainability and open competition. Still, there is a degree of momentum building. More impetus is certainly needed. The EU is not on the verge of pursuing this legislative agenda in an aggressive manner. It certainly needs a major politician at national level, perhaps within the Commission, to adopt this as a pet project and to push harder towards the EU acting as a legislator. But there is, as those slides have demonstrated, a degree of momentum which is building within the European Union system in favour of a firmer commitment delivered through legislation to establishing ground rules that must be met for good governance in European sport. So the idea is ex-ante regulation to supplement the ex post facto application of competition law. It's not a unique idea. It's exactly what happens already in digital markets. These two regulations, the Digital Markets Act and the Digital Services Act, both adopted this year, both adopted under Article 114, which is the legal base for harmonisation in the internal market, which is the legal base I am advocating for sports regulation. Both of these measures fit exactly the pattern which I'm suggesting. The assumption underlying the adoption of this legislation is that digital markets are regulated by competition law, but that often the harms that are committed within these markets are either not readily identifiable as competition law infractions, or if they are, once they are, it's too late to put them right. So these instruments establish standards that must be met by all operators within digital markets, operating in supplement to and in advance of the application of competition law. So platforms have obligations they must meet, stipulated by these legislative measures as a precondition to entering the digital markets and operating on it. The terminology is even resonant. These platforms are referred to in the legislation as gatekeepers. That's why the EU imposes obligations on them. They're gatekeepers. They're very important in securing access to the markets. Well, that's exactly the terminology we would use for sports governing bodies as well. They're gatekeepers too. They decide who should be put on and who shouldn't. Just as an example of the way that this system works, it's explicitly provided in the Digital Markets Act that sharing personal data across platforms is strictly controlled. You could imagine circumstances in which sharing personal data between two or more firms would be an anti-competitive practice within the meaning of Article 101. You could imagine circumstances in which sharing personal data by dominant operators would contravene Article 102. But the point of the Digital Markets Act is that you don't need to go through the analysis required by Article 101 or Article 102 to establish the obligation not to share the data. The obligation not to share the data applies to all operators in the market, irrespective of the way in which they do it, as long as they count as platforms that are gatekeepers within the Act. So this is a regulation which is more comprehensive than competition law and which applies as a precondition to access to the market rather than as a means of disciplining conduct on the market after it's happened. So that's the model I want for sport. The competition law will continue to apply, but there will also be preconditions placed on the conduct of sports governing bodies before they're allowed to operate in the European Union. So what form should EU intervention take? Of course it should take the form of dialogue, exchange of best practices, institutional cooperation. The EU can act in a soft way to encourage better practice. But we need more than that. We need to move beyond competition law to regulation, to targeted legislative proactivity. Can I be more concrete? Yes, I can. Part of my point is that EU legislation should be introduced and that there should therefore be a political process within which it can be considered what type of obligation should be imposed on sports governing bodies in order to make sport better. And that political process at EU level would allow a voice to all affected interests in a way that all affected interests do not have a voice in the pyramid organisation of football governance. But it's not my job to say exactly what should be in the EU legislation. It's the job of the political process to draw on all affected interests. But here are some suggestions. I divide into the three blocks the type of obligations that I think the EU should impose on sports governing bodies operating within the European Union. Standards of good governance generally. Standards of good governance in application to sport in particular, mandating the model of sport. Standards of good governance generally, first of all. 3 examples, the types of things I think that the EU should put in place through legislation as a precondition to acting as a sports governing body in the EU. First, term limits. UEFA has had 6 presidents in 50 years. FIFA's had 4 in 60 years. Both the current presidents of UEFA, Alexander Ceferin, and FIFA, Gianni Infantino, were re-elected unopposed in 2019. That's not healthy. The power of patronage of individuals who hold power for that long is far too great. There needs to be a more rapid turnover. There needs to be fresh input. There needs to be contestation when it comes to electing presidents. So we see different agendas, different approaches, what to do, what and why. So the European Union could usefully legislate to establish maximum periods in which individuals may hold office in sports governing bodies. Remember, key point, sports governing bodies are not going to do that for themselves. Second point on standards of good governance generally, better representation. Sports decisions, as I've explained under the pyramid of governance, are taken by sporting insiders. The FIFA Congress, the FIFA Council, the previous FIFA Executive Committee, and the FIFA President are all voted for by national football associations and only national football associations. Again, that's not going to change from within, so the EU should legislate to ensure that there must be greater representation of affected interests. Players, fans, most of all. Third, human rights. The European Union should legislate to require that governing bodies which put on football or other sporting competitions within the European Union shall comply with defined human rights standards. That's pretty easy. But it's not just that. There's no reason at all why those obligations should be restricted to tournaments within the European Union. There should be an external reach as well. Why shouldn't the European Union require national teams who participate in tournaments which are staged outside the European Union shall participate only provided the host country meets the stipulated human rights standards found in EU legislation? So, clubs, national teams based in the European Union should not go and play in countries where, for example, women can't attend matches on the same basis as men. Clubs, national teams in the European Union should not go and play in countries where homosexuality is illegal. Standards of good governance in application to sport in particular takes us into issues of club ownership, fan representation. Should we give fans more of a voice in the way in which clubs are run? Should we give fans a stipulated role in determining the ownership of clubs and in determining the direction that clubs take? Should we give fans, for example, a veto over name changes or colour changes, reflecting the cultural worth of a club? Yes, I would like that to be on the agenda. It seems to me to be something that could usefully be the subject of legislation. An automatic response might be, well, this is club football and so is probably better left to be decided at national level, because there are probably different approaches in different states across Europe. I would counsel against that. That would be playing into the hands of the sports governing bodies, who are really good at picking off individual states that try and develop initiatives, imposing sanctions on them to prevent this kind of intrusion into the autonomy of sporting governance. If anyone's going to do it, it's got to be the EU. The European Union has the advantage of being a bloc of 27, which is resistant to sanctioning by sports governing bodies. So these kinds of adjustments to the standards of good governance applying to sport in particular, belongs to EU intervention. Again, if anyone's going to do this, it's the EU, only the EU. Thirdly, mandating for a particular model of sport. Should the EU legislate as to what shall be the model of sport? Open leagues, closed leagues, merit-based qualification. I'm more cautious here. This really does get to the heart of sporting autonomy, decisions on what a sport should look like, how a sport should be constituted. It seems to me are much closer to the legitimate zone of autonomy that sports governing bodies may claim. So I'm rather sceptical whether the European Union should go so far as to actually legislate for a European model of sport. But it may well be useful for the European Union to put in place legislative rules on how governing bodies shall address applications from third-party organisers to put on competitions. So, on the third of those sets of agenda items for legislative action, I'm reticent to see the European Union being too aggressive. But watch out for the political dynamics on this. I haven't mentioned UEFA yet in the context of assessing whether there's likely to be political will to adopt EU legislation. Your automatic instinctive reaction might be that UEFA would be horrified at the idea of good governance standards being imposed on it by the European Union. They would howl about the importance of defending sporting autonomy. And maybe they would, but consider this. Imagine the European Super League case goes disastrously badly for UEFA. Imagine that the Court of Justice decides that UEFA has no legitimate role in excluding an entrant competition such as the Super League. Imagine that the Court of Justice decides the case entirely in favour of the Super League on the basis of a hardline competition law analysis that this is a new product which should be admitted onto the market. And if UEFA suffers as a result, then so be it. If that were to be the outcome of the European Super League case, I think UEFA would suddenly become very interested in surrendering its autonomy and seeking the embrace of the European Union legislative procedure. UEFA would immediately want the EU to legislate to protect the European sports model. So the dynamics would be very interesting. And if UEFA were to be interested in acquiring legislative protection for its pre-existing model from the EU legislative process, then I would suggest that a package deal might be struck whereby UEFA might accept protection of its model, but while also having to accept significant adjustments to its governance model, greater representation, term limits, human rights. So, what's that European Super League case? It's important on its own terms for determining the relationship between UEFA as a regulator and the Super League clubs as the provider of a new competition. But it's also enormously important in affecting the dynamics, the patterns of demand for legislative action in response to judicial decisions. Most of all, though, what I want is for that to be changed. I want that pyramid to be changed from a closed model of governance to a much more responsive model of governance. Of course, FIFA's rules have global reach, the European Union's don't. But choices made by the European Union often have extraterritorial effects, largely because of the immense economic power that the European Union possesses. It's commonly known as the Brussels effect. So changes within the European Union may be changes which are not confined to the European Union. I talked about an example of this yesterday, whereby the transfer system was changed in the European Union after the Court of Justice's ruling in Bosman, and those changes were applied across the entire world by FIFA, because of the impossibility of running two separate transfer systems for the European Union and the rest of the world. So where the EU led, the rest of the world followed. Well, would something similar happen if the European Union were to legislate for improved governance, for intensified commitment to human rights? Well, it might. If the European Union were to prohibit its clubs and its national teams from playing in countries where homosexuality is banned, FIFA would have some difficult decisions to make. It could simply continue to host tournaments in countries where homosexuality is banned, but it would lose among the most powerful and economically important participants in its competition. Or it could stop hosting tournaments in countries where homosexuality is banned, in which case the European Union would have exported its model. Brussels effect. Is that virtuous, or is that imperialist, colonialist? I'd really be interested in hearing what you have to say. But remember, if it's not the EU that does that, no one else will. The European Union is uniquely well placed to improve the quality of governance in sport. It should be more proactive, though not to the extent of displacing the primary role of sports governing bodies as regulators of their sport. The aim to improve, but not to replace, governance by sports governing bodies. That's all I want to do. Make sport better. Thank you.